Good afternoon. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru, Tumarkin, and the Western Canada practice leader for employment law. I'm here today to answer all the questions you might have related to employment law, related to your rights at work. We're going to try and get through as many of those questions as we can today over the next half hour. So don't be shy. Put your questions into the chat. We're going to try to get through as many of them as possible before the end of the show today. If we miss out on any questions, our next show is this Wednesday, where Mr. Lluc Cerda will also be here to answer any employment law questions that you have, and he'll be on at 1 p.m. Eastern Time on Wednesday. So, as some of you might have already realized, Boxing Day is upon us. Boxing Day is this Friday, November 29th, the unofficial start to the holiday season. When the holiday season comes around, I always like to remind my clients and my viewers, if you are taking time off over the holidays, it's important that you schedule it and that you have that time off approved before you take that time off. Every year, we'll hear of someone who, thought that, the office was going to close anyways, so they didn't book the time off, or their employer said they needed them, between Christmas and New Year's and won't give them the vacation. And then these people end up taking unauthorized leaves of absence to go on a trip or what have you. It's important to get that locked in, especially before you buy your plane ticket. Make sure that you have locked in that you are allowed to take the time off before you buy your plane ticket. Problem is, I see it every year. Some people come back and tell me, well, I took an extra 2 days of vacation that wasn't approved, and now my employer wants to terminate me for having taken this unauthorized leave. Sorry if I'm sniffly today. I'm battling a seasonal cold, so bear with me over the next half hour. Now, is it an automatic termination for cause if you take those extra 2 days without authorization? Probably not, but it's a lot simpler in this case to ask for permission rather than ask for forgiveness. So before you buy your plane tickets, make sure that you've locked in that you can take that time off. And before you buy your plane tickets, make sure your employer knows that you are now buying plane tickets based on their word that you can have these days off. All right. So just make sure you do it the right way. I think you'll save yourself a lot of aggravation upon your return from holidays in January. All right. We had some questions roll in during that discussion. We have a question coming in from YouTube from Tammy. I've been released to go back to work in September since September 24th. My employer is not allowing me to return. They are now saying the decision has been sent to corporate. Cannot my employer stop me from returning to work after a leave? Okay. So that also does come up. And I'm very sorry for Tammy that you're going through this at work. So essentially, you're ready to go back from a job protected leave. It could be a maternity leave, a medical leave, any kind of leave that you have that is job protected. And you go and you try to get your employer to take you back in the role that you had, and all of a sudden they're not getting back to you. They're telling you there's no job for you. They're working out some things. No, at some point they have to give you that job back. And if it's since September, we are now going on. It has been 2 months. That's too long, Tammy. Basically, your employer seems to me that they're not taking you back. So you've been terminated. You could treat that as a termination, which means that you're entitled to severance. If you're looking to know how much severance you might be entitled to, you can visit this great website that we have called Severance Pay Calculator. It's at the pocketemploymentlawyer.ca, pocketemploymentlawyer.ca. You answer 4 quick questions. We'll give you our estimate on how much severance we think you're owed. But it's not just severance in your case. If you're coming back from a job protected leave, is it a medical leave? Is it a maternity leave? That's a job protected leave. If you are terminated upon returning from job protected leave, it looks like that could very well be some form of discrimination, either gender-based discrimination because you took a maternity leave, or disability discrimination, which means that can also open up avenues for you to be awarded human rights damages and things of that nature. So if that's what's happening to you, Tammy, I think 2 months is a very long time. And if they are telling you that they are just not allowing you to return, and it seems they've made their decision, how much longer are you going to wait for them? I suggest you give us a call. Get in touch with us, and we can help you get the compensation you're owed. So if you want to reach out to us, that's employmentlawyer.ca. Employmentlawyer.ca. Get in touch with any of the lawyers here to be able to help you out with this matter. All right. So the next question is coming from Ron20. Ron asks, can an employer say that your workplace accommodation requirements is not possible and fire you for requesting it? A few things. So no, they can't fire you for having requested an accommodation. That would be a form of discrimination, which means that would be, again, as I was explaining to Tammy, you'd be owed severance. It's not your fault that you required accommodation, so it's not a just cause termination. So it's a without cause termination, which means you'd be entitled to severance. And if the main reason why, or even one of the reasons why they terminated you is because you made an accommodation request, and that would be discrimination as well. More often in my practice, what I see happening is an employer will say, well, we cannot accommodate your restriction. You have a restriction that requires X, Y, and Z. We can't do that. That amounts to undue hardship. So if that's the only way that you come back to work, then don't come back to work. Stay on leave. Stay on medical leave. All right. So that's how most employers would deal with it. They would say, stay on your medical leave until that restriction is lifted, and you can come back without that restriction to do your duties. And then it becomes a little bit of a battle is it really so impossible for the employer to accommodate that restriction? So you didn't really give me too many details of what it is you were asking, Ron 20, from your employer. I can tell you a lot of employers are quick to say, no, we can't do that, right? The law requires that they accommodate you to the point of undue hardship, which means that some hardship is expected of the employer. This can't just be, it's a mild complication for us to do this, so we're not going to do it. All right, that won't pass muster. That'll be seen as a failure to accommodate on employment, on human rights legislation. That said, there are some things that legitimately you shouldn't be able to require your employer to do. Like if you've suffered disability because of harassment, and now you're asking, the only way I can come back is if you fire this other person, that's probably not going to be something that can be accommodated. So it kind of depends what it is you're asking as an accommodation. Feel free to put that in the chat if you want. I can give you an idea of whether I think that is something that you should normally expect your employer to accommodate you for. We have our next question coming in from Renee French. Renee asks, typically, how much longer must you wait for your entitlements when using an employment lawyer? Well, I can tell you a lot of our matters resolve very quickly, right? I mean, so generally you have, you're terminated, you come see us, book a consultation with a lawyer. And then after that, the first steps that we usually do is write to the employer telling them, listen, we don't think that what you've offered, Renee here is a good severance. And we start negotiating, right? And so typically within 2-3 months, we have a very large chunk of our matters are resolved, done, the money's paid, and you're moving on with your life. What I try to stress to a lot of people when they come to me is that this offer that your employer has made you for severance is really an opening offer, all right? So you can expect, or they can expect, that you will come back with a counter offer, right? And they want this wrapped up as much as you do. Right? They don't want most employers, more rational employers, do not want to litigate, your termination, your severance entitlements for years and years and years. They want to come up with a number that's fair for you, that allows you to move on with your life. And so a great amount of our matters resolve within 2-3 months is typically what we're looking at. All right, we have a question coming in here from Mailman. Mailman asks in BC, ESB is very backlogged. Wait is 6 months or longer for wages owed. Are there other means besides filing an ESB complaint? I have not been paid for 3 months and counting. Wow, that is pretty dramatic, mailman. Um, I do not think there is necessary. There would be a quicker way than 6 months to get you paid through the court system, because the other option would be through the court system. All right, and if you have already started an ESB complaint, you're likely barred from then also doing the same thing through the court system. So that's a little bit of the complication that you have there. Is that if you have not been paid, though, I can tell you at some point you don't need to continue working there. You can treat that as a constructive dismissal. Okay, you'd be owed your severance, which of course gets us back to kind of square one. These are people that are not paying out even wages. How will they pay out severance? And this might be an exception to the previous question from Renee, is that we're going to have to start enforcement proceedings and go through the litigation process. Unfortunately, it does happen sometimes that the people that come see us have been terminated because their employer lacks funds or is about to go bankrupt. It can be very heartbreaking and frustrating to hear that after all these years of work that you've done, your employer goes bankrupt, and your severance, you're still owed your severance, but so is every other creditor of the bankrupt employer is owed some money, and so you're in that pool with those creditors. So I would stop necessarily, putting good money after bad here, mailman. If you're not getting paid, it doesn't make sense to continue working if your employer at the end of this may be out of money, right? So definitely reach out to us, especially if you've come to realize, listen, there's no future for me here. I need to go find another job, and I may as well get my severance while I can. Reach out to us. We can help you go after your severance. If you haven't been paid in 3 months, that's you don't have a job anymore. Let's be frank. I mean, the most important part of a job for the employee is to get paid. If you're not getting paid, it's not a job anymore, and you're owed your severance. So you saw the email on the screen there. It's employmentlawyer.ca if you're looking to reach out to us. All right, we have another question coming in here from Graham Soth. Graham Soth asks, my employer wants to sell his business to 2 new owners. They have both said they are not likely going to keep me. Who owes me severance, and how do I go about requesting it if I'm let go after the sale? And Graham Soth has followed up. Can I go after them for wrongful dismissal? They said I'm not cheery enough. Is this defamation? Okay, a few questions there. So in the sale of a business, it happens a lot. We get a lot of questions about this sale of business. Who owes me severance, or whatever it is that you're fighting about? Like, they haven't paid my overtime in six months. And now they've sold the business. Who owes me the back pay for overtime pay? Who owes me severance? All right. It's not that it's overly complicated, but it's not like there's a bright line rule either. Essentially, it kind of depends on how the company is sold. Okay. Companies have a name. Okay. Just to start off, let's use an example. ABC Inc. Okay. ABC Inc. is a company. And ABC Inc. is a company that's owned by Joe, let's say. And Joe sells ABC Inc. to Ben, all right? So, and Graham is employed by ABC Inc. So the fact that the owner of ABC Inc. went from Joe to Graham does not affect anything. Graham is still employed by ABC Inc., all right? If ABC Inc. terminates him, it's whoever ABC owes him the money from ABC's assets. If Joe wants to put in his own assets, or Ben wants to put in his own assets to pay that off, that's fine. But it's ABC that owns the company. All right. Now, other companies are not structured this way. All right. Other sales are not structured this way. All right. So you'll have, for instance, a company called ABC Studios, but that is actually just a name that it carries on business in, and it has a very different, weird name that it uses, that is its official name, like 123 Alberta Inc., for instance. All right. And so 123 Alberta Inc. sells ABC Studios to 345 Alberta. All right. And Graham was employed by 123, and now 345 is not going to hire him. And so 123 owes him the severance. Okay. So it kind of depends on what the relationship is. And now to everyone, Graham works for ABC Studios, right? But ABC Studios is not the real company. It's just the business name of the company. So all that to say, someone is going to owe you severance, Graham. Don't worry about it. It's not like you could sell the business and just say, okay, we don't need these employees anymore, and that's it. It's over. Someone owes you severance at the end of this. Kind of depends how the sale was done. It's a minor wrinkle. It's not even a complication. I wouldn't even call it a complication. Figuring out who owes you the severance. Basically, the way we do it here, we just go see the corporate registry. They tell us who the owner is, and we figure it out in about 2.5 minutes. But I can't do it right now on the show. But Graham, if they are going to terminate you, you are owed severance. They are probably going to give you a termination letter at some point, and that'll be an indication of who it is that owes you the severance. If you're not satisfied with the severance you're being offered, reach out to us at employmentlawyer.ca or visit the Pocket Employment Lawyer. Now's a good time to do it, Graham, to figure out how much severance you're likely owed. So the severance PayPal calculator is at pocketemploymentlawyer.ca. All right. So visit that, and that'll help you understand what kind of compensation you're looking at, Graham, because this can be a substantial amount of funds depending on how long you've worked there and some other factors. So you want to treat this as with the importance that this kind of financial decision deserves. All right. So make sure that you cross your T's, dot your I's, do your due diligence, figure out what your entitlements are, so that you know whether what you're being offered is actually fair and reasonable. All right. We have another question coming. And lastly, Graham, about the defamation. They told you you're not cheery enough. Is that defamation? So just very quickly, just a rule of defamation. It's kind of interesting. If I tell someone that Graham is not cheery and that's a lie, that might amount to defamation. But if I tell Graham to his face that he is not cheery, that is not defamation, okay? Because Graham knows enough about himself to know that whether or not he's cheery. So he has not been deceived by me telling him he's not cheery. So that can't be defamation, all right? It has to be said to a third party about you. It can't be said to you about you for it to be defamation. So keep that in mind. If they go around spreading the rumor that you are not cheery, then potentially that could be defamation. But if they just said it to you, then that wouldn't be defamation. All right. We have another question coming in here from Clive, the driver. Clive is asking, before I get to Clive, we have a question came in from Sergio on YouTube. Sergio is asking, are you able to help foreign workers in Canada? Yes, absolutely. So if you are located in Canada, in the provinces that we service, which is BC, Alberta, and Ontario, even if you're a foreign worker, if you are located here and working for a company here, then we can help you. Okay, absolutely. So reach out to us, employmentlawyer.ca, if you have questions about your employment rights as a foreign worker or anything like that. Definitely we can help you. All right. Clive, the driver, is asking, hi there. I'm from Ontario. I'm using your law firm, been at the company that is closing its doors in January 31st. Been there 26 years. I'm 58. Just wondering how long the process takes. So Clive, I was answering that question a little bit earlier. Maybe you hadn't joined the show. A lot of these negotiations actually happen pretty quickly. All right, we're looking at 2 to 3 months to get things resolved for a good number of our clients. So generally, the steps are: once you've been terminated, you come to us. We have a consultation with you, discuss with you a little bit, what the law says about your situation and what you can expect as an outcome. from the process, and then you hire us, and then the process begins. And generally, that's writing to the employer and explaining to them how the law applies to your situation and what are your likely entitlements in terms of severance pay, and then begin negotiations to get you that severance pay. All right, and if everyone's acting rationally, that generally takes at best 2 to 3 months to get you really sorted and paid. All right. So, and during that time, people tell me, well, I can't afford no salary for 2 to 3 months, and that's a very fair consideration. There are certain amounts that are owed to you at termination that you don't have to negotiate for. That'll be paid to you within a couple of weeks of your termination, like 2 weeks is what I'm trying to say. And those are certain minimum entitlements you're owed under various employment standards legislation. So it's a lot less than what your full entitlements might be, but it's owed to you right away. All right, so that allows you to have something to tide you over until the bulk of the severance comes to you, right? So, pick up the phone, because you definitely won't be walking away from a job with absolutely no money at all, even if you don't sign your employer's settlement offer, the severance offer. There will still be some amounts owing to you, and then we'll negotiate to get you the right amount for your total severance entitlements through some negotiation with the employer. All right, we got another question coming in from Smarty Artie. Smarty Artie asks, do verbal contracts or promises from an employer hold up at all in terms of having a legal claim? My employer has promised me a raise and title change for hitting my targets, but is denying it now. The problem, Smarty Artie, a verbal contract is a contract, okay? So it can be enforced the same way a written contract can be enforced. The challenge, of course, is proving that there was a verbal contract, okay? So if there is some proof, some admission by your employer that they agreed that they would give you this raise and promotion if you hit your targets, but now for whatever reason they can't do it, if you have something proving that that contract was in place, then maybe you could do something about it. That might amount to a constructive dismissal. It's like saying, well, we'll give you this bonus if you work really hard, and then once you've done all the work, we're not giving you the bonus anymore. In my view, that would amount to a constructive dismissal, okay? But the challenge is your employer admitting that they had promised you this, but they just can't give it to you now? If they are, then the fact that it was verbal is irrelevant, because now they've admitted that they agreed to this. But if they're denying they ever told you this, then we have a proof problem. All right. So how are we going to prove that this is actually what the agreement was? All right. So my advice generally, when you get these, I was reading a post on LinkedIn earlier this week, and this woman was making a comment: if it's not in writing, it's not real, right? And this was in the context of her negotiating the terms of her potential employment, future employment with a future employer, where they were making all these great promises, and then when she'd ask for it in writing, they would just not agree to put it in writing. So lesson learned, unfortunately, Smarty Artie, if they're promising you these things, these handshake deals often go sideways. It's easy. You don't need some notarized, lawyerly contract. Just an email is enough, right? A written trace that this conversation happened, right? Hey boss, just wanted to confirm, you said that if I hit my targets by the end of the year, I'll get a raise to X amount of dollars, and you'll give me the title of, whatever manager. Just can you confirm that that's what we discussed, that I got that right? Boss replies, yeah, absolutely. That's all you need. You don't need anything more than that, right? But if it's not in writing, it's not real, right? Keep that in mind. All right, we got a question on YouTube from Adar. Adar is asking, I made a mistake at work, and instead of firing me, my director issued me a warning because he didn't want to lose me. I found out that the company is going to be restructuring and removing my role along with a number of others in middle management. Can they use my past mistake to fire me for cause now? Great question. Great question, Adar. And the answer is no. Okay. When you are guilty of misconduct at work, okay, your employer has a toolbox of forms of discipline that they can use um, uh, to signify to you that what you did was misconduct. And of course, the most extreme tool in the toolbox is termination for cause. All right. And there are some things that, will amount to termination for cause. I always say if you're stealing from your employer, chances are you're not going to get a second chance there. All right. So, but for instance, say, just to use an example, I'm not saying this is what you did, Adar, but say you're caught stealing, you've stolen, $20 out of the till. All right. You're caught red-handed. Your employer could totally terminate you for cause right there. Your employer instead says, you know what, I'm going to give you a 2-day suspension. Even though I can terminate you for cause, I'm going to give you a 2-day suspension without pay. Come back in 2 days, you can have your job back. Even though had they terminated you for cause, it might have been upheld. The fact that they said, in my view, really 2-day suspension is probably going to do the trick here, means that they can't change later on. 3 months down the road, it would have been convenient had we terminated Adar because now we're restructuring. Let's change that 2-day suspension into without a for-cause termination. Can't happen. All right. You have the right to have a judge determine whether they actually had just cause, and the judge is going to say, no, listen, you guys said 2 days was enough to punish Adar for whatever she did. You can't now change it to just cause. Now, because you did that, I'm going to find that it's a without cause termination, and you owe Adar all the severance you would have owed her when you terminated her. All right. So if that does happen, Adar, feel free to reach out to us. We're at employmentlawyer.ca. All right. All right. So we have 3 more questions and comments, and then that'll be the end of the show. But I'm going to get to the ones that have been put in so far. So if you put in your question, I'm going to get to it. Don't worry about that. So my name, once again, I'm Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, and I'm the Western Canada Employment Practice Leader. So I'm here today answering your employment law questions. Anything related to employment law, I'm here to help you answer those. And if I don't get to your question today, we are going to get to that. We are going to have another show on Wednesday at 1 p.m. Eastern with Leo Samfiru himself. We'll be taking and answering your employment law questions. So if I haven't gotten to your question today, feel free to tune in on Wednesday, 1 p.m. Eastern. All right. Clive the driver is just mentioning, thank you. Many of my coworkers are using your company, and we are bouncing off each other. Have they heard anything? Well, okay. Oh, okay. Yes. So typically what happens once we send our letter out, the employer gets the letter, reviews the letter, panics a little bit, and then goes through the process of hiring their own lawyer. And that right there sometimes can take an extra few days. And then the lawyer has to get up to speed. That's why it takes maybe 2 to 3 months, because some things have to fall into place before all the parties are well represented and able to talk numbers. Otherwise, we just pick up the phone and do some back and forth and get it done in an afternoon. So if that's what you're worried about, Clive the driver, we are on top of that. We work hard to make sure that, if they are hiring a lawyer, that they hire that lawyer quickly, that lawyer gets up to speed quickly, that our lawyer gets a response to us, to our lawyer's letter ASAP, because we know, Clive the driver, that you're at home without an income now. And you want to get paid, right? So we want you to get paid as much as possible, as quickly as possible. That's the whole reason why we do what we do. So definitely, I will look into that. If you want to send me an email, I can also look into to seeing what I can do to help expedite the process, Clive the driver. So send me an email. You have my contact information and the QR code there at the top of the screen. I'd be happy to take a look and help you out. Clive the driver, if QR code is not working for you, my email's on the website. Just look up my name, Lluc Cerda, in Google, and you should get my company profile. All right, or I'm at employmentlawyer.ca right there. Smart ERD is following up. I guess it's a matter of put up and shut up. They would probably fire me if I argued for it. Smart ERD, I would tell you, this is your decision to make here. I don't think that they could fire you for cause for calling them on the fact that they promised you something. All right. If they do fire you, it would be on a without cause basis, and you would be owed severance. I mean, depending. If you go in there kicking and screaming and breaking things, probably not. But if you're approaching this as a reasonable person, saying, I worked hard and got these goals based on the belief that my success would be the company's success, would be my success, right? That we would be in this together. And now you're kind of telling me, no, none of that. The only thing that matters is the company's success. My success does not matter. If you're having that in a kind of rational, even-toned kind of conversation, I don't really think that they can terminate you for just cause and deny you severance. All right. But you might not want to even leave even with a severance package. So you might rather stay than leave with a severance package. So if that's the case, and that is unfortunately your options, is to put up with it and learn your lesson for next time. If it's not in writing, it's not real. Okay. So keep that in mind. And we have a last comment from Tammy Hoffman. Tammy was saying that Tammy was the one who tried in September to go back to work from what I'm now learning is a medical leave, and the employer would not take her back. So Tammy, unless they're saying that you needed an accommodation that they can't accommodate, they needed to take you back. So a long time ago, like 2 months is too long. So like I said, if you're looking to have us help you out, I think you should. We can definitely help you out. And the worst that happens is it speeds up things and gets you your job back. All right. So reach out to us. We're at employmentlawyer.ca because, I've seen people call. They call me up. They're like, I've been trying to get back to work for a year and a half. Right. I've been trying to get back to work for a year and a half. I've been cleared to return to work with no restrictions for a year and a half, and I keep getting in a runaround. And so, Tammy, I ask you, like, how long do you want to wait, right? And then I get involved and we get this stuff sorted, right? Because you're not a priority for them right now, unfortunately. And with our help, you can become that priority that you need to be, right? So that your life is not left in limbo while they try to figure out what they're going to do with you. All right. So reach out to us, employmentlawyer.ca. We're happy to help you there, Tammy, to get you sorted. All right. So once again, that's it for me. My name is Lluc Cerda. I am the managing partner of employment of the Calgary office of Samfiru Tumarkin. I am the Western Canada Employment Practice Lead. It's been my pleasure to answer all your great questions today. We have another show on Wednesday, 1 p.m. Eastern. Lior Samfiru is doing the show. Join us then. We'd love to hear your questions once again. And thank you all for joining. And we'll see you next time. Bye now.